Good evening, everyone. We've gotten through all our technical difficulties. Thank you for joining. I'm Michael Ettinger from Ettinger Law Firm, and we have a nice group with us tonight. Um, about 50 of us here this evening so far, although we just started. So let me introduce you. You can add questions as we go along. I'm going to hold the questions till the end. But I want to thank you for joining my webinar entitled Four Advantages of Using Trusts. Here is the firm. There I am in the middle. My lovely wife and law partner, Suzanne Ettinger, to my left on your screen. A number of our other lawyers and support staff. The website is trustlaw.com. Anything you need to know is on trustlaw.com. Hundreds of articles on elder law, estate planning, on every imaginable topic. Ettinger Law Firm's practice is limited to trusts and estates, wills and probate, estate tax saving strategies, Medicaid applications, and Medicaid trusts. We have 12 offices throughout New York State, 5 on Long Island, 2 in Nassau County, Lake Success, where I spend a considerable amount of time, and Rockville Center. In Suffolk, we're in Huntington, where I am this evening, and I also live in the town of Huntington in Centerport, New York, with my wife, of course. We have 3 offices in Suffolk. We're in Melville, Islandia, and right here in the village in Huntington. Staten Island, 900 South Avenue. Westchester, we're at 140 Grand Street in White Plains. Rockland, 345 North Main Street in New City. Orange County, we're in Middletown by the police barracks, Crystal Run. Dutchess County, 2 offices. We're in Fishkill and Rhinebeck. And Albany, right there at 125 Wolf Road, where we have been for over 35 years. So with that, let's get started. The topic is elder law estate planning. So I think it's fair to ask, what is elder law estate planning? If you just joined us, you can type in your questions as we go along. We're going to hold all the questions till the end so as not to break people's train of thought. So elder law estate planning is an area of law that combines the features of elder law, which is really disability planning, and estate planning, which is death planning. Of course, maybe it's a little more than that, but that's a very broad overview, so you can distinguish what's elder law and what's estate planning. Here at Ettinger Law Firm, we like to say we use trusts to create order out of chaos. And that is because trusts avoid the pitfalls of wills by saving considerable time and money in settling the estate. Most people today know that trusts avoid probate, the legal process to prove the will valid. Trusts avoid legal guardianship if you become disabled. No one wants a court to step in and appoint a stranger to handle your affairs. Trusts can keep assets in your bloodline, so they end up going to your grandchildren instead of to in-laws and their families. That's the Inheritance Protection Trust. I'll be talking about that a little later. And finally, trusts are valuable, the Medicaid Asset Protection Trust, to protect your home and life savings from the extraordinarily high cost of long-term care. And one of my favorite words in elder law estate planning is control. If I actually had to summarize all of elder law and estate planning in one word, the word would be control. You're basically keeping control in your family and out of the court system. And I also like to say, your control is only as good as your backup plan. So part of having control is having a backup plan that you fashioned with your people in charge. So let's get started with the 4 reasons why trusts are preferred over wills. First is, trusts protect you from guardianship proceedings if you become disabled. Wills don't. Well, a will, of course, most of us know takes effect on death, so it's exclusively a plan for what happens after you're gone. However, it is no plan for what happens if you become sick, homebound, or disabled, which eventually happens to about half of all people. A trust, on the other hand, is a plan for all 3 phases of your life. Today, while you're healthy and competent, you pretty much run it yourself. It says who takes over if you become sick or disabled, or if a doctor puts in writing you're unable to handle your legal and financial affairs. And similarly to a will, who gets the assets after you're gone, but again, without the expense and delay of a probate court proceeding. So we mentioned about half of all people have a period in their life where they can no longer handle their affairs. And if you don't have a plan, New York State has written a plan for you. Many of you, I'm sure, have heard of it. It's called guardianship proceedings. Now, you may think, well, that's not going to happen to me because I have a power of attorney for somebody to handle my legal and financial affairs if I become disabled. But surprising to most people is the courts in New York have the power to cancel your power of attorney and put somebody else in charge. Now, how does this happen? Well, in my experience, it happens most often by nursing homes applying to become a legal guardian because they want to make sure that they're in control of the money and that they get paid. And because they have the person in their custody, so to speak, the courts are very sympathetic to their needs because they have the expense and the care of taking care of the person. So a judge can easily cancel your power of attorney and put somebody else in charge. And now the court is going to choose who your legal guardian will be, and it may and often is a stranger. Now, you might think, well, they'll pick one of my adult children. They're capable. However, some of the judges feel your children have a conflict. What's the conflict? Well, if they spend it on you, it's coming out of their inheritance. There may be sibling rivalry. More than one of them wants to become the legal guardian. The judge says a pox on all your houses. Or the judge determines they're not capable, they don't have the knowledge or experience to be a legal guardian. Many reasons why your people may not be picked. The issue here is now they appointed a legal guardian. You cannot get back control without a court order. Well, just imagine trying to get back control after a judge has appointed a legal guardian. It's very, very difficult. We want to avoid it in the first place. These proceedings are expensive, time-consuming, and stressful. They involve multiple court proceedings to determine the nature and extent of disability. The court has to appoint a court evaluator to meet with the alleged incapacitated person. That's actually a term of art, the AIP, alleged incapacitated person, to determine a court evaluator determines the nature and extent of the disability, makes recommendations to the judge as to the nature and extent of the guardianship needed. This is obviously going to take a lot of time. It's going to be all at the expense of the AIP, alleged incapacitated person. It's very stressful. You don't know how long it's going to take. You don't know how much it's going to cost, and you don't know who is going to be put in charge. Another issue with guardianship is now your family is not in charge, and neither is your lawyer in charge to help you move to protect assets because the legal guardian is in charge. What I'm getting at here is we can generally, even if somebody's done no planning, we can generally save about half the assets right on the nursing home doorstep by moving them out of your name to your children. And there's a name for this technique. It's called half-a-loaf planning, after the expression, which of course everyone knows, half a loaf is better than none. I can usually save half by moving the assets out of the ill person's name. We move half and they get to, as long as we spend the other half on mom or dad's care, the family gets to keep the half. It's an advanced elder law technique. We do it all the time. However, once a legal guardian is appointed, they can't use that technique to save half the assets because the legal guardian cannot move mom or dad's money to the kids because they're guardian for mom or dad. They can only spend the money on the person they're guardian for. So you can get, first you'd have to have a favorable legal guardian who would be agreeable to make an application to the judge for permission to protect assets. Well, I learned a good lesson a few years ago. I actually prevailed on a legal guardian to make an application to the judge to move to protect half of mom's assets by moving to the kids under the Medicaid law. The judge turned down the application. The judge said, in my opinion, it's mom's money, should be spent on her for her care, and if there's anything left at the end, the children would get that. Why did this happen? because the judge was in charge. So we got the judge's values instead of the family's values. That's why you don't want to lose control, because people have different views of things, and conflicts can arise between what your family wants and what the guardian wants. Clearly, we don't have to beat this to death. Nobody wants a guardianship proceeding. So let's talk about how to avoid it. A trust avoids guardianship because, unlike a will, the trust takes effect while you're living, which is why they call it a living trust, and it stays in effect if and when you become disabled. So here's how it works. Let's say your name is Mary Jones. We set up the Mary Jones Trust. We appoint you, Mary, the trustee, and we retitle the assets from your name, from Mary Jones, to Mary Jones, trustee of the Mary Jones Living Trust, dated whatever. So put in your investments, your bank accounts, real estate, everything except IRAs. IRAs don't go into a trust because they are protected from Medicaid. They're exempt, and they're protected from probate to have a designated beneficiary. They are later on, you'll see, part of the estate plan, but for now, IRAs, 401ks, 403bs do not go into the trust. So now your assets are in the trust, and you carry on the same as before. But fortunately for us, we can name the backup trustee, one or more persons, to act if you become disabled. So now you have a plan where the people you picked are in charge. That is ironclad. The people you know and trust are in charge instead of legal guardian. Now, you remember I said earlier, the judge can cancel your power of attorney, put somebody else in charge. But fortunately for us, the judge can't cancel your trust. So the trust defeats the guardianship. And it's one of the main reasons we like trusts. Unlike the guardianship, where you have to go and ask judge for permission, here you take back control whenever you recover because it's between you and your family. At Ettinger Law Firm, sometimes we like to say planning for disability is more important than planning for death, because planning for disability is for you. You come first. Planning for death for somebody else. So as I said, the court cannot override the trust. Guarantees you get the people you choose in the event of disability. So that's where you're taking back control. Right now, your people are in charge instead of the judges in charge. Before we leave this subject, I want to talk about the elder law power of attorney. Not all powers of attorney are created equal. The standard form, the one that most lawyers use, I'll call that over-the-counter medicine. This one is prescription strength. And it works just like medicine. What happens if you only have over-the-counter medicine and you need prescription strength? You know what happens. It doesn't work. It's not strong enough. Exactly the same with the power of attorney. And here's what I'm getting at. We need a stronger power of attorney to transfer and protect assets in the event of disability. The standard form power of attorney that most lawyers use, the one issued by New York State, the statutory form, allows your agents to make gifts in your name up to $5,000 a year. So let's say you have $500,000 and you have to go into a nursing home. You may recall earlier I said I can save $250,000 by moving it to the children. Half a loaf planning, right on the nursing home doorstep. But if you only have the standard power of attorney, it says they can only give $5,000 a year. So guess what happens? In 3 years, you managed to save $15,000, and you spent all the $500,000 on your care. So the facility got $485,000. Your family got 15 instead of 250 because they don't have the prescription strength power of attorney. So the elder law power of attorney has an unlimited gifting power. This says that the people you choose and trust can move any amount of assets, hundreds of thousands, out of your name, because under Medicaid, it's move it or lose it. So if we can save it, we'll be able to save it because they can move as much as they need, any amount. So we like trust to avoid guardianship, keep control in the family, your people in charge in the event of disability, and for assets outside the trust, like the IRA, you have our prescription strength, elder law power of attorney. The second reason why trusts are preferred over wills is because the famous one, trusts avoid probate and wills do not. So let's look at this item. Well, there's that word control, my favorite word. You lose control when you have a probate because you have to submit the will. Now, you wrote the will, with your lawyer. It was witnessed, it was notarized, the lawyer supervised the whole thing. However, nobody can use that will unless a judge has determined that's a valid will. And that means it has to go to court, and proof has to be made that at the time of signing that will, you were of sound mind, memory, and understanding. You were not under any fraud or undue influence. A few other proofs. Okay. So it goes in, the court has control because you can control up to the point of the petition, but when the petition gets sent to the court, it's out of your hands. It could take weeks, months, years. You have no control. You have to wait until it's approved by the judge. Now, you don't want to be go calling them, asking them what's happening. They don't like that. They would just want you to sit by and wait. You have no control over the matter. But this can cause lengthy delays in getting access to your money and other assets. Probate causes a hardship in many cases. Can't sell the house, can't list it for sale because the executor is not approved. So you're carrying an empty house, could be months or longer. You want to buy and sell stock, the market's not going well, you're trapped, you're just subject to whatever the market does, and you can't take any steps because you're not appointed, it's in the deceased person's name. You can't pay bills, you don't have access to bank accounts, all kinds of unpleasant effects there. So you pay very handsomely for this privilege, maybe 2 to 3% of an estate on average goes to probate court proceedings in terms of court fees and attorney's fees. It's time consuming. Obviously, it takes much longer than a trust because the trust doesn't have the court proceeding. And there's that word stressful. We're anti-stress here at Ettinger Law Firm. We like to, we consider our prime mission, our number one priority is to reduce anxiety, stress, and fear in our clients and to do it as quickly as possible. We can't do that in probate court because it's outside of our control. But if we have a trust, then we can control these gremlins, let's call them. Not only that, but the will is a public record. Anybody can go down and look up how much you had, who you left it to, including where they live. So nobody wants that. So we want the privacy of a trust. Doesn't get filed in court. Nobody knows how much you had or who you left it to. But obviously, this is not a pleasant scenario. So let's look at how we avoid that. Well, trusts do not have to go to court to settle, which means we don't have to make any proofs. The time savings is incredible. I mean, a trust, you can act in just, you might need a week or two to get the death certificate so you can change the name of the trustee on the trust to the successor trustee. And that's only on revocable trusts. Irrevocable trust is different. We'll get to that. But you're going to save a lot of time. The value of saving time is inestimable because people can get on with their lives. It helps with the grieving process, saves significant legal fees. Even in a middle-class average estate, it's going to be quite a few tens of thousands of dollars. And of course, no court costs. So there's that word control. The court is not in control of your estate. If you die, it's your family's in charge. Your backup trustee can be more than one person. They can act, virtually immediately. I would say maybe a couple of weeks after death, they'll be in a position to act. Don't have to get appointed by the court. I mentioned this earlier, worth mentioning again, the trust is private. Because it doesn't get filed in court, it's not a public record. We don't have to give notice to anybody. Only if people named in the trust get to see it. If you're leaving somebody out or you're leaving them less than they think they're entitled to, they can't get any information. They're not a party. They can't challenge it. Lawyers don't even like to take on trusts because it's generally an unsuccessful proposition. So if you're leaving somebody out or you're leaving them less than they think they're entitled to, you're pretty much going to prevent them from any kind of challenge. And it's going to make it much easier for the kids who you are leaving it to not have to deal with the ones you aren't leaving it to. We want to mention the multiple probate problem. Let's say you own property here in New York in one of these pastel-colored condos in Florida. Do you know you have to probate the will in New York and Florida, called the multiple probate problem? So if you own property in another state, you're going to be looking at two probates. But when we set up a trust, we can deed the property from any state into your New York trust and avoid all these probates. So you avoid what's called the multiple probate problem. Just a word to the wise. So we like trusts to avoid probate, saves time, saves money, and saves a tremendous amount of stress. We're anti-stress here. Our job is to get things done, to reassure you you don't have a problem, and to take care of any issues that arise. So reason number 3, trusts protect the inheritance you leave from children's divorces, losses, and creditors, keeps your assets in the bloodline for your grandchildren. Well, who doesn't want that? Let's look at the problem. This is called the Inheritance Protection Trust. And why we do it is because let's say you die and you leave your daughter $500,000. Unfortunately, a few years later, she dies. Where does your $500,000 go? To her husband. Can he get remarried? Share your $500,000 with a complete stranger? Of course, happens every day. So that's not what people are doing who are maybe a little better informed. They appoint their son or daughter as the trustee of their trust. So you have a daughter, Mary. We're going to create a Mary trust. I'm going to say, Mary, I'm leaving your money in the Mary trust. You're in charge. You can do whatever you want with the money. Buy, sell, trade, spend. You can spend the whole thing. I'm not ruling from the grave. What's the advantage of the trust? Well, it protects the inheritance if she gets divorced. It protects the inheritance if she gets sued. And main thing is, it says when she dies, it goes to her children. And if she doesn't have children, it goes to her brothers and sisters. The assets do not go to her husband and his family. Same thing if you have a son. You can also protect the beneficiaries against themselves by having somebody else as a trustee or a co-trustee. A lot of people need protection because their son or daughter has a challenge. And some of these challenges are obviously alcohol or substance abuse problems. They could be special needs. There's a broad spectrum of special needs. They could be a soft touch. They could be a spendthrift. They could be controlled by their spouse. Run into this problem a lot. Son or daughter is controlled by their spouse, and you don't want their spouse controlling your money. So all these things can be done, dealt with effectively in the Inheritance Protection Trust. Something to talk about in the consultation. Let's dig in a little deeper. So we know it passes the inheritance on death by blood. Here's our family. There's Bobby and Mary, the grandparents, grandkids, the whole 3 generations. There's Mary, she dies. It doesn't go to Bobby and wife number 2. It goes to the 2 lovely children, your grandchildren. If it doesn't have children, as I said, it goes back to brothers and sisters and nieces and nephews, but it stays in your blood. Now, some people are very fond of their in-laws. They tell me, oh, my son-in-law is a prince. I want to take care of him. That's fine. You can do this. You can say, if Mary dies and she's still married to Bobby and they're cohabitating, living together as husband and wife, give half to our grandkids, keep the other half in trust for Bobby, give him the income for life, and on his death, give the second half to the grandkids. So this way, you can give him an income interest in a trust. This way, if he gets remarried, wife number 2 doesn't get the assets. He just gets the income for life, and on his death, the grandkids get the second half. It's an option. I'll tell you, most people don't exercise it, but a few people do. So it's nice to have. The bottom line is your careful planning will continue for decades after you're gone. Here I say at Ettinger Law Firm, we take care of you for your lifetime and beyond. Very popular. I invented this trust in 2008. We've done many tens of thousands of them. They're very, very well thought of, very popular, and they do yeoman service. Reason number 3, we like the Inheritance Protection Trust, which doesn't exist in a will, to protect the inheritance from divorces, losses, and creditors passed by blood instead of by marriage. Reason number 4, trust can protect your home and life savings from long-term care costs. Wills clearly can't do that because the will takes effect at death, and by the time you die, there may be no assets left because it all went to your care. So people are very interested in the famous Medicaid Asset Protection Trust, the MAPT, which we've been doing since I founded Ettinger Law Firm in '91. So 35 years experience with the MAPT. So Most people put their house because it doesn't matter to you if your house is in a trust or not. Everything's the same. You pay the bills, you mow the lawn, and you carry on. The trust says you have the exclusive use and enjoyment of the real property. So you have life rights. And you put certain other assets into the trust to qualify for Medicaid benefits. This trust sets up three roadblocks that Medicaid can't break through. Well, it's called an irrevocable trust. Now, I know it sounds strange, but in New York, you can revoke an irrevocable trust. It's irrevocable because the people set it up. If you're single, it's you. If you're a couple, it's both of you. Uh, the single or couple who set it up cannot revoke it themselves. So far as you're concerned, the law says that's an irrevocable trust. Fortunately for us here in New York, we have another rule on the books that says that if every person named in the trust agrees in writing that they no longer want the trust, you may revoke it on the written consent of all the named parties. Well, that's you and your children. If everybody signs, you can undo it. Later on, I'll show you, even if one of them won't sign, I could have a workaround, but we'll get to that. So the key here is you can't be in the revocable trust, you're married, trustee, married trust. In the irrevocable trust, you can't be the trustee because if you're the trustee, Medicaid will say, well, you can get it, take it out and give it to us. If you could get it, they could get it. So you have to name somebody else. People almost always choose one or more of their adult children. Medicaid has no control over them. And the Medicaid trust is called an income-only trust, which means what it says. You only get the income. You can only get interest on the FCDs, you get the interest, dividends on your stocks, etc. You can't get principal because if you could get it, Medicaid could get it. So you put the principal out of your reach. Let's look at why people do that. Well, it doesn't affect your lifestyle. You still get all your income, your Social Security, your IRA, your pensions, your interest, your dividends. So it doesn't affect income. That stays the same. Most people are living in their income. It makes sense for assets you're not going to spend, like your home. That makes perfect sense. Any out-of-state property or vacation property. What about the investments you're only taking the income from? Well, then protect the nest egg because the trust will give you the income. A lot of people aren't even taking the income; they're just reinvesting it. Look, if you have a nest egg that you're not spending, then you're actually safekeeping it for the long-term care industry. It makes more sense to protect it for your family, so it'll be there. You have the exclusive right to use and enjoy your home. You keep all your exemptions, senior, star, veterans. You have control over the trust by reserving the right to change the trustees at any time. So you can change who you leave it to, and you can also, I'm sorry, you can change who's in charge, and you can also change who you leave it to. So remember I said a few minutes ago, you can uh, revoke the trust on consent of all the named parties. What if son or daughter says, I'm not agreeing to undo the trust? You say, okay, I'm taking you out as trustee. I'm taking you out as beneficiary. You're no longer a party to the trust. I don't need your signature. Thank you very much. Uh, Look, not likely to happen. But the reason I'm mentioning it is because I want you to understand you have control. You can undo this trust at any time. So it's not what it sounds. So Medicaid only gets the income. If you need Medicaid, they get the income. Well, they get the income anyway. You got to pay your income for your care, but your nest egg is safe. Now, let me just spend a moment and digress about the Medicaid Asset Protection Trust. Some of you may know I write a column every week in every major newspaper where we have offices. I've been writing it for 4 years now. And a few months ago, I wrote a column entitled, In Elder Law, There's More Misinformation Than Information. Very, very difficult to get the right information. This is why I've written books on the subject, because my books are on Amazon. Everybody reads them. Nobody's found any mistakes in them. So the information distilled. You can get the right information. But is it ever hard for you to go onto the internet and start looking around? Because there's a lot of bad information, incorrect, or it doesn't apply in New York. So try to take the information that is distilled. You can go to my website, trustlaw.com. You can download my book for free. You can order it on Amazon, not expensive at all, and get the right information. Um, a lot of people, even elder law attorneys, oddly enough, don't get this right. Now, how could that be? Well, it took me a long time to figure out why a lot of elder law attorneys don't get it right. In other words, they don't set up the Medicaid trust allowing you to change the trustee or allowing you to change the beneficiaries. And I finally figured out why that is, because a lot of lawyers who set up the Medicaid trust have never filed a Medicaid application. So they're very conservative. They're afraid to put in the powers to change who you leave it to. They're afraid to put in the powers to change who's in charge because they don't know if Medicaid will accept it because they never filed for Medicaid. Well, here at Ettinger Law Firm, we filed over 6,000 Medicaid applications. We know exactly what works. So our trusts are very flexible because we're not afraid of Medicaid because we've been doing it for 35 years. Medicaid doesn't care about these provisions, but you have to know about Medicaid and apply for it to know what works and doesn't work. So our trusts, I think, are the most flexible in the industry, um, and you need it because uh, you want to protect your asset, but people do not want to give up control. And with this trust, you don't give up any control. So I like the trust. So the trust can sell the house, buy another place. So what happens? The trust sells the house, the money's paid to the trust. Trust buys the next place. Doesn't start to 5 years over again. You can buy and sell and trade your stock. You like to run your stock portfolio after you set up the trust, you can continue to do that. We know there's a 5 year look back for facility care and possibly a new 2.5 year look back for home care. I think I need to change this slide because they've gone quiet on that 2.5 year look back for home care. It didn't pass in 22, 23, 24. It didn't pass. I didn't hear much about it in 25 and nothing in 26. I don't think it's coming back. So there's no look back for home care. You set up the trust, you put your assets in, you're eligible for home care the very next month. Now, I said you can't take out principal because if you can get it, Medicaid can get it. But what if you need $50,000 to take your whole family and your lawyer on a trip to Disney? We can't take out the 50, but you can make a gift to your son or daughter of any amount, tax-free, any amount tax-free. They can't give it back to you, but they can spend it on you. And let me explain. When I apply for Medicaid for you, I have to show them what you took out of your name and put into the trust. But I don't have to show them what the trust gave to somebody else. So you give your son or daughter 50,000, they pay for the trip, and off you go with your happy lawyer to Disney. IRAs, 401ks, and other retirement plans are exempt, protected from Medicaid, except for the RMDs, required minimum distributions that you have to take out. It's income that goes towards your care if you need care. But the nest egg is protected, IRAs, 401ks, 403bs, and they avoid probate because they have a designated beneficiary. Still part of your estate plan because we're going to change the beneficiaries on IRAs and 401ks to those inheritance protection trusts to protect the IRA and 401k money if they get divorced or sued and passed by blood to your grandchildren instead of to in-laws and their families. So it's part of the estate plan. You know, it always pays to get started. Let's say you set up the Medicaid trust. 4 years later, you have to go into a nursing home. Well, you only have to pay for 1 year because you already got 4. In other words, it prorates. It always pays to get started. After 5 years, you're home free. So we started with an introduction. An introduction, we said, estate planning with trust creates order of chaos. Well, let's look at how it does it. It avoids guardianship on disability. It keeps control. There's a word control in the family. And you have asset protection options because you're going to deal with your lawyer and your family can have the full range of asset protection options that Medicaid allows. It avoids probate of death, keeps control in the family again, saves significant time and money in settling the estate, keeps your affairs private. Protects the inheritance you leave if the children get divorced or sued, pass it by blood to your grandchildren instead of to in-laws or families. Protects your home and life savings from long-term care costs, makes you eligible for Medicaid for home care and nursing home care if and when you need it. Well, this is orderly, isn't it? Compared to the chaos of a guardianship, a probate, assets passing to non-family members and losing everything to long-term care. So where do we go from here? The law firm has a unique planning process. There's a copy of my new book, 2026 edition, just been updated. It's called Ettinger Law Firm's Guide to Protecting Your Future, my third book on the subject, Distilled Information. So the planning has already begun with this seminar. And We invite you to a no-cost initial consultation, very low key. Uh, we meet with you. Uh, we talk about your family, your children, what kind of work they do, how many grandchildren do you have, where do they live, that sort of thing. What about yourselves? We look at your assets, we look at your current plan, review that, see if it's adequate. If it's not, we'll explain why. In plain English, we explain things. You know, we're all about educating you and building your confidence. I don't like to tell clients what to do. I like to educate clients so they're in a position to choose what they want to do. I had somebody today consulting with her in a Zoom, and she said, "Well, you're going to have to convince me to use a trust." I said, I don't convince people to use trust. I educate people about trust, and then they decide if that's what they want to do. Uh, the key here in estate planning, every person, virtually, not every person, but virtually every person that comes in to see me or Suzanne or any of the other lawyers at the firm are at a low level of confidence. They don't know what they don't know. They don't know what they're missing. They don't want to look silly. Um, all kinds of things are going on. But we recognize this, that everybody's low confidence. Who knows about estate planning until we educate you? And we do it in plain English. This book is written in plain English. I have a 37-minute video on my website. In fact, when you got the confirmation, for, I believe, or when you make an appointment to see me, hopefully, you'll get the 37-minute video sent to you so you can watch it ahead of time. Covers everything you'll need to know. We're going to give you a free copy of my book, and we'll tell you which chapters apply to your situation after we meet with you. We're also going to tell you how much it will cost. Everybody wants to know how much it's going to cost. Well, it's based on a number of factors, but it's not based on how much you have in assets. We have a fee schedule. Depends on what you need, not what you have. So we'll go over that with you. And we're going to ask you to come in for a second meeting to have the questions answered. So you read those chapters, you write down your questions, you watch the video. Now we have that second meeting where there's no fee. We're going to answer any questions you have. We're going to draft the estate plan together with you. Who's your first and second choice for medical decisions? Who do you want to handle your affairs if you become disabled after you're gone? One person, more than one person. How do you want the estate paid out, all at once or over time? Any special situations, special needs, other issues? We answer all those issues. We help you draft a plan that will work socially. So if somebody asked me, what's the difference between you and another estate planning lawyer? I would say the number one thing is we do the social work first and the legal work second. So we're going to get to know your family dynamic, who gets along with who, what's the issue, do you like your in-laws? Are there any issues? Do they control your children? Are there any problems? We're going to try to get to know your family from a social point of view, which will help us determine what will work legally and give you some options for what we think will work best and why, what other people do, why they do them, how things work out. Now, we've drafted the plan together. We got input from you. We made suggestions. You made some choices. Now we give a detailed written proposal. It's the same fees we mentioned the first time, but now it's in writing. Here's a list of what we're going to do. Here's how much will it cost. And of course, the choice to go ahead is yours. You don't pay any money at the second meeting. If you decide to go ahead, we give you the fee proposal. You don't sign anything. We say, this is what we're going to do, and we make an appointment for you to come in and do it. But we don't take a retainer. We don't actually take any fees until after your documents are signed. So far as I know, we are the only firm in the United States of America that does not take a retainer agreement to do estate planning. Never seen or heard any other firm do it. And that is because it's not the way lawyers are trained. I was trained like every other lawyer. If somebody wants to go ahead, uh, ask them for a check for half the fee and the balance when they come in and sign. Um, well, I did it the same way every other lawyer did it until one day it dawned on me that I wasn't doing it the right way, and here's why. I just gave a talk of maybe an hour or so, well, not even, maybe 40 minutes, on taking back control, control, control. I'm all about giving you control and keeping control. And then I realized one day, the way I was trained is not the right way to do it because if you give me a check for retainer, half the fee, what do you have? You have nothing. You have a promise. You have to hope I'm going to perform, and you have to hope I'm going to perform to your satisfaction. In other words, when you give the lawyer that check per half, you have a loss of control. It doesn't make sense. Why would I give a seminar all about taking back control? And the first thing I do when you come into the office is take control away from you. So we realized this. Once we analyzed, we said, look, the best thing for you, the client, is to pay at the end when everything is done and you're satisfied. Now, if we're here to serve you, and that's the best thing for you, then by definition, it must be the best thing for us. This is one of the best things I think we've ever done because we only have happy clients. Nobody pays us until they're satisfied, but of course we make sure people are satisfied. We want to get paid. So we both have an incentive to do a good job. You come in for the final meeting, we review the documents, and you sign everything. And you can, well, people don't pay by credit card much these days because we have to charge the 3%. But most people pay by check and get paid at once. You could do 2 installments or 3 installments, um, and that'll be your choice. So it's a very low-key, comfortable approach. Um, we enjoy doing it. We enjoy meeting with you, and I think you'll enjoy it yourself. Now, once you become a client, we don't say goodbye. The standard in New York is thank you very much, goodbye. In fact, even the New York State Bar uh, uh, feels that estate planning is a transaction. We don't feel that way. We think it's a relationship. So I was listening to a CLE, continuing legal education, which I have to do 24 hours every 2 years. Uh, and it was quite interesting. A panel of so-called experts, we had ethics counsel, we had defense counsel, we had elder law counsel. They said after you sign your plan, we should send you a letter, and in the letter we should thank you for your patronage and state that this concludes our representation of you in this matter. And the reason they say we should send the letter is because it starts the statute of limitations running from the time the representation is ended. So if you had made a mistake, they won't be able to sue you later on. How do you like that? Well, that's because lawyers, the way they're trained, is they're concerned about the 1 in 10,000 clients who are going to sue them. Here at Ettinger Law Firm, we're more concerned with the 9,999 that aren't going to sue us. So I'm not concerned about that. I think it's nonsense, and we don't do that. We don't say goodbye. We say hello. Now we say you're going to get our Ettinger Elder Alert. Comes by email, so it'll keep you up to date on law changes. We call you in every 3 years for a free review. See if there are any changes in your health, your assets, your family, births, deaths, marriages, divorces. But we're also building a relationship. It builds up over time. Because estate planning is a relationship. People die, people become disabled. You don't want to go see a stranger. You want to go see somebody you knows who knows the family a little bit and has some compassion. It's hard to have compassion for somebody you haven't seen in 25 years. So we've been doing this for 35 years. It's a tremendous process. We actually build relationships with clients, multi-generational, actually. We don't charge for phone calls, emails, questions. Why? Because we want you to be able to communicate with us without worrying about getting a bill. So it's an open door policy. So now you sign, you're a client, you're going to get our law letter once a week, you're going to get a free review every 3 years. We call you in, we don't wait to hear from you, and you can call or email anytime you have a question. I mean, that's a valuable service. But by using this program, your plan is never more than 3 years old, which means what? It's going to work when you need it. Not when you signed it, hopefully quite a few decades earlier. So we've saved a lot of people, a lot of problems, needless to say, with that. So to schedule your no-cost consultation, it'll be with me if it's my schedule in one of my offices, or Suzanne. She runs Melville and Islandia. I go to White Plains, I go to Staten Island, I go to Rockville Center, and I go to Huntington, Melville. but it'll be with one of our lawyers. It can be in office, by video, by phone. Let me say that in person is more valuable for you and for me because the communication is better, the relationship building is better, but not everybody can do it. So we make ourselves available by video or by phone. That's Zoom or by phone. But you'll choose what's best for you. You just call the 800 number or go to the website trustlaw.com. It's very easy to make the appointment. There'll be prompts. It's like a walk in the park, really. So now I'm going to stop the share. I'm going to answer the questions. We have about 19 questions plus a number that were sent in ahead of time. So I hope you'll stay and join us for the questions because you can learn a lot from them. Ida says, how is a Medicaid trust beneficial if you know you don't want to go to a Medicaid nursing home? Well, because the Medicaid trust also qualifies you for home care, so you can get Medicaid to pay for your home health aides. Now, Ida says, if you're in an assisted living, which is private pay, and run out of funds, and have an MAPT, the assisted living can now legally throw you out. Well, if you don't pay the bill, of course I can throw you out. It's private. Medicaid doesn't pay for assisted living. But if you're on Medicaid, a Medicaid facility, they can throw you out. What they can do, though, is if you have to go to the hospital for something, they don't have to hold your bed. And if they're full when you come back, that could be a problem for you. But they can throw you out if you're on Medicaid. Ronnie, if I wrote a piece of paper stating to my executor what's to be and who the house gets and has it notarized, is this legal temporarily? No, it does not legal. Wouldn't be recognized by any court in New York. Would not override your prior will. Absolutely not. We don't have homemade wills. They're called holographic wills in New York. They're not accepted by the court. Anonymous says, what is the difference between a life estate and an irrevocable trust? Well, there's quite a difference there. So I wrote an article on it on my website, but the life estate gives you the right to live there for your lifetime. But let's say you have to go into a nursing home. If they sell, now the house is empty. If they sell the house, the life estate has a value, generally about 1/3 the value of the house. So 1/3 will go to the nursing home. Whereas if you have an irrevocable trust, they can sell the house and it's in the trust, it's protected already. So life estate has a number of drawbacks. The other drawback is the irrevocable trust you can undo. You have control. The life estate, it's over. Now that you sign the deed over to your kids and have the right to live there, if you change your mind and they won't sign, you're finished. There's nothing you can do. I've had a lot of people come in and be sorry about the life estate because they can't get one of their kids to sign to undo it. I never want to put a client in a position where we can't undo what they did because circumstances change and people change their minds. We don't paint you into a corner here at Ettinger Law Firm. Life estate is actually, it's completely irrevocable. You can't undo it. So it limits your options later on. Okay, now Ronnie says, can I just add my son to the deed? Not a good idea because if he inherits it from you, he pays no capital gains taxes. If his name on the deed, he only inherits half from you, he has to pay capital gains taxes on the other half based on the value you paid for the home in the beginning. We can talk about that when you come in. A pour over will, Ronnie says, Ronnie has a lot of questions. What's a pour over will? With the trust, you get a will that says, in case there's a loose end, something I overlooked, pour it into my trust after I'm gone because the wishes are written in the trust. Okay. Usually we don't have to use it because we make sure if it's not in the trust, it's joint or has a beneficiary. Ronnie asks about a DNR, do not resuscitate. The healthcare prog, your agent, so a DNR is something that your healthcare agent signs in the hospital when there's no hope of recovery and you're in extreme disability. They don't want you to be resuscitated. But you don't sign it ahead of time. It's based on the circumstances. Ida says, do you have to provide account numbers when creating a trust? No, because you're going to transfer the assets into the trust at the bank. If you have a brokerage account, you give us the email of your broker, and we'll handle it directly with them. We'll give them the trust with the instructions. Um, we don't, any information that we get in the firm, we are very, very high security, probably better security than your bank. Um, it's very hard to get into our system. It's even hard for us, and we work here. So we have firewalls. We have every kind of security. We have state of the art. Not only do we have the state of the art security, but our security people are upgrading it all the time, constantly upgrading for whatever the current level of security is. Um, you don't put an IRA or a pension into a trust. No, those are exempt from Medicaid, and they're exempt from probate. Marla, is it true that trusts are mainly for our children? Uh, well, no, it's for you if you become disabled. Um, so a trust is a good plan for disability for you and to avoid probate for your children. Lawrence, can revocable trust protect against lawsuits? No, it cannot, because you can take it out any time. It's available for your creditors. Lou says, am I allowed to keep my required minimum distribution for my IRAs? Yes, with an MAPT, yes, because remember, Lou, the IRAs don't go into the MAPT. The MAPT doesn't affect your required minimum distribution. Uh, with a will, you get the trust, you get the pour over will. I mentioned that. Geneva, how much does it cost to set up a trust? You have an office in New York City. Well, first of all, I do not have an office in New York City. My closest office is in Lake Success on Long Island, or in White Plains, uh, or Rockville Center. I'm actually a short train ride away in Rockville Center. The train's across the street. It's maybe a 5-minute cab ride in White Plains. Cost setting up a trust these days, I would say generally they run 6,500 and up, depending on revocable, irrevocable. Do you need inheritance protection trust for the children? Type of thing we talk about in the consultation. Lou says, how are my brokerage accounts named in trust? So, like I said, Lou, you give us if you have a broker, we work with them. If not, we'll fill out the forms for you to change the name to the name of the trust. Not a problem. If you're the trustee, you'll be the trustee. If it's a Medicaid trust, son or daughter will be the trustee. Anonymous, at what age do most people draft a trust? Yeah, generally 65 and up. There's no fees after you change the trust, after you set up the trust. If you want to amend the trust, there's fees, but amending the trust is not putting assets in or taking them out. Amending the trust is changing who's in charge or changing who you leave it to. Probably will not happen very often, if at all. Lawrence, we cannot do a New York trust. If you're a Florida resident, depending where you are in Florida, if you're anywhere near Palm Beach Gardens, Boynton Beach, Delray, go to CarpLaw, KARPLAW, carplaw.com. That's who we recommend, Jonathan and Joseph Karp. Let's see what we have here. Paul, can I get a trust on a co-op so it doesn't go to probate? With the co-op, Paul, you have to contact your managing agent, ask them if they permit a transfer of the co-op to a trust. About half of them do, half of them don't. Michelle, there's no tax return for the trust, so we don't have to worry about the cost of the tax return. Now, quite a few questions sent in. We talked about the cost of trust. I said about 6,500 and up. That's for Jenny. Okay. Age of the trust, generally 65 plus, unless the exception to that would be if you're over 7 million, you'll need a trust to save New York estate taxes. If you have property out of state, you may want a trust to avoid the multiple probate problem. Now, Lawrence, you asked, why have irrevocable trusts gone out of fashion in most presentations? Now, that was a strange question for me. I didn't know that. I can't say why. I can say that a lot of lawyers don't understand them. A lot of lawyers aren't trained in elder law. They just do estate planning, irrevocable trust or elder law. But I've given over 6,000 presentations in my career, and everyone had about the irrevocable trust, and it's our most popular trust. We do hundreds and hundreds of them every year. Carmen, how to pass our hard-earned assets to our children and best account to leave a legacy to our grandchildren. Well, not only does the inheritance protection trust make sure it goes to your grandchildren, but I am in favor of leaving gifts to your grandchildren because I think it raises their self-esteem. Imagine getting a gift from your grandparent, $100,000 when you're 28 years old. I mean, that gives you a real boost in life. It might be a down payment for a place or pay off college loans, and makes them feel better about themselves that they got something from their grandparents. You know, it creates a richness and a depth to the family that wouldn't otherwise exist. And I make sure that they get the money, that their parents don't spend it on them before they ever see it. Patricia, can I gift my two daughters money from my estate without them or I paying taxes? Yes. You know, you can gift up to 15 million, 15 million tax free. You just have to report the gift, but there's no tax. I'm already a client. Okay, thank you. Okay. Um, so when you set up a trust, you do get what's called the stepped up basis, Alex, which means your heirs inherit your assets, whatever they're worth on the date of death. So let's say your house you bought for 250,000. When you die, it's worth 500,000. The kids get it as if they paid 500. So they paid 500, they sell it for 500, no gain, no tax. Death wipes out the capital gains taxes. Norma asks, should I pass the deed of the house to our children to avoid Medicaid taking it over? You don't want to deed the house to your children because you might change your mind and then it's too late. They already have it. Put in the trust. If you change your mind, you can take it back. Upon purchase, what are the advantages of putting property into a trust if you're young with no heirs? There's no reason to put in the trust if you're young with no heirs. A will would be sufficient for that purpose until you get older. Rich says, if I put my assets into an MAPT, my income level is still too high to actually qualify for Medicaid. I doubt that. A lot of people are of the impression that there is an income level. It doesn't work that way. You can shelter the income with a pooled income trust. It's another subject, but you can look it up on my website. Another attorney informed me that I could utilize a buy down option to pay off qualified expenses. As a matter of fact, yes. Let's say you have a mortgage on the house of 200,000. The day before you need Medicaid, you could pay off that mortgage, and the 200,000 will disappear because that's not a gift. There's no penalty. You paid a bill that you owe. Okay, so that's paying off qualified expenses, usually a mortgage. Linda says the trust for your two adult children. You have the one with mental health issues and a physical disability. That's going to be a special needs trust, which we're familiar with. And your second child will probably manage the trust. And we'll plan for long-term care for you as well. I'm sorry, that wasn't Linda, it was Carolyn. Okay, Carolyn, we can do all that. Lou, who we answered, your will and you have a will and all your accounts have beneficiaries. Well, there's nothing to keep it in the blood, protect the kids to get divorced or sued, and nothing to protect it from long-term care. So you may want to reconsider an MAPT unless you have adequate long-term care insurance. Also, even if you have beneficiaries, you don't have a plan for who takes over if you become disabled. The trust does that. This person said, I didn't see the name, just a letter C. So I given my children large monetary gifts over time, but it never amounted to over $1 million. Do I need to fill out a tax form? The answer is technically yes. That's all I can say about that. Yeah, the trust is tax neutral. This looks like I'm not sure what the name is, but asking about income taxation of trust. All our trusts are tax neutral. They get taxed to you individually. They don't get taxed to the trust. John asked me about the importance of REITs, a real estate investment trust. Those aren't trusts really. They're actually investment. They're investment vehicles. David Lerner is famous for REITs. Talk to them about REITs. They know everything there is to know. We talked about the stepped up basis. Okay. Patricia has parents who are 92 years old. They're paying for home care for the past year, which they shouldn't because we can apply for Medicaid for home care. Remember, there's no look back. We just put the assets into the trust and then apply for Medicaid for home care. So you shouldn't be paying for that. They're starting to run out of money unless they sell one house. Well, selling the house, put them in the trust, and then will apply for Medicaid for home care, like a walk in the park. Um, if you have an irrevocable trust, can you sell your house? Ruth asks. Of course, the trust sells the house. The money's paid to the trust. Trust goes on and buys the condo. It's still protected. You don't start the 5 years over again. Vincent wants to know, when you set up a trust, do you put insurance policies? You change the beneficiary on the insurance policies, Vincent, to the trust. Um, your IRAs, you're going to still leave it to the named beneficiaries, but they might have an inheritance protection trust. Um, Now, the type of trust depends on your age, your assets, where your property is. So we have to talk about that in a consultation. Should your children be named as beneficiaries in the trust? Cynthia asks. Yes, no problem with that. Um, do trust prevent access to your money? Gary, no, I don't believe so. Even the Medicaid trust, you can gift it out to your children. You get the principal out if you need it. You change the beneficiaries at any time. Um, uh, Helen asks, she wants control of her assets while they're in the trust for the time being. Well, if you want to protect assets, you have to put your children in charge, but your control is you can change who's in charge and change who you leave it to. Okay. Um, IRAs we know are protected. You can put New York and non-New York property into the trust. Beverly wants to know, can she put her co-op into the trust? You have to ask the co-op board, Beverly, if they permit you to put your shares in a trust. About half of them do, half of them don't. Jack says, I hear trusts are much better than will on many levels. Is that correct? Well, yes, of course, from the presentation, you can tell that, but we still do wills. Some people, I'll tell them to wait. They don't need a trust quite yet. They might be too young. Um, but generally 65 plus, the trust starts to make more sense. Now we have more questions from the group here. Marilyn says, what if you don't have anyone competent to manage the trust? Then you can choose us here at Ettinger Law Firm. We'll do it for you. Joel says, if you can only take income from the trust and there are lots of stock, how can you liquidate stocks to generate cash? Well, the trust can sell the stocks and gift out the cash to your son or daughter who can spend it on you. Michelle, is inheritance protected trust an addendum to the main trust or need two separate trusts? They're separate trusts, Michelle. So you have your daughter would have the married trust, you have your trust, and yours pays to her trust. Here's Ida. Can you please restate what you mentioned about protecting assets with the MAPT, even your own income is still very high to qualify for Medicaid? Well, any assets that you need to be able to stay in your own home, any income. So anything you can expense out, your mortgage, your all your bills, that income doesn't count for Medicaid. We can shelter that income. So after all your expenses, your income probably is not going to be that high to pay for your own caregiving. You might be able to pay for a little of it, but not all of it. Medicaid will pay for the difference. And if you're able to expense out all your income, then Medicaid will pay the first dollar of your care. Type of thing we need to come in, explore a little more fully, but there's no such thing as your income being too high to qualify for Medicaid for home care, unless we're talking income of maybe 200,000 or so, that's going to be a problem. But usually we can shelter out your income with the pooled income trust. You can go to my website, trustlaw.com, look under practice areas, and look under Medicaid for the pooled income trust and read about it, and it'll educate you. So I think oh, there we go. Paul, I have a will. Can trust, yes, the trust will replace the will. You get a new pour over will, Paul, with the trust. By law, the new will counts as the old will, so your old will is void. You don't have to go back and get it. It's not hard, Ronnie, to sell a home in a trust because the people who are buying it don't care who the seller is. There's no restriction on selling the house in the trust, so it's not an issue. Joel, after giving, can they give you back cash without? No, because if it, well, I mean, cash is cash. Nobody's actually going to know to be real, but they can't give you back the money and put in your bank account because Medicaid will see that. They'll say, where did that come from? And it came from the trust. You're finished. So, um, you know, cash is cash. I don't want to comment on it, but you can read between the lines. So let me thank you all for coming this evening and getting through this rough winter here we're having. I'm born and raised in Montreal, so for me it's like old home week, but not everybody has that background. So I want to thank you for coming. Thank you for listening, and hope to see you all in the office very soon. Have a nice evening, and thank you for joining. Bye now.